is an altercation, there is no criminality to that, and there is no threat to him.
So that has been decided by the committee.
Not the committee, my lord. The superintendent of police has responded.
What is the procedure in this regard when a PSO is sought for?
He has to apply, my lord.
Have you applied? Where is that?
Page 47. My lord, at this juncture, my lord, what I want, my lord, at least some protection be given to me, my lord. I don't want, my lord, at this.
One thing, if I may most humbly submit, my lord, his charter is the medical reports that he's relying on. There is nothing to evidence as evidence of a criminal attack on him, my lord.
This is nothing but a misguiding, my lord. Lordship, kindly have a look,
no,
page
my lord.
31, my lord. I was hospitalized, my lord. It is a blunt thunder card.
You are well aware that so far relating to the protection and security, first procedure is that they must have a satisfaction. We cannot have that satisfaction.
Before that, my lord, I like to apprise page 31 be seen for a moment. How I was brutally.
No, that we agree. We agree that her position is not correct. This is not a civil dispute. Forget about that. This is assuming for a moment that there is some
My
threat
lord,
to your
if
life.
some protection is not given, my lord, as a interim measure, my lord,
No.
I'll be eliminated.
That is difficult. From
My
this
lord,
scope.
at least OC, my lord, at least OC, concerned police station, provide some security, my
No,
lord.
my lord.
My residential area. I don't want, my lord, for few days only.
We can issue a notice, ask them to file an affidavit.
Lord,
As
that will be-
this regards, what
Lord.
is their status as regards security threat?
my lord.
Let them place this matter before the committee
I
and
don't
what.
want permanent, my lord. Security running after me. I don't know. I want to
Heard
survive,
Mr.
my.
J.I. Borbar, Land Counsel for the petitioner. The grievance of the petitioner is that প্রথমখিনি লিখিব ইয়াৰ পৰা ফাৰ্ষ্ট পেৰাগ্ৰাফটো আগৰ অৰ্ডাৰ 15/3/2024 pursuant to this court's order dated 53/2024 MS S Sharma learned government council submits that the CS received certain instruction and may be granted 2 weeks time to file 10 days time 10 days time to file an affidavit. Full stop. Accordingly, let a notice be issued returnable after 10 days. MS Sharma learned the council accepts notice on behalf of
All the respondents.
all the respondents. Full stop. All the respondents. In the meantime, the superintendent of police Kokrajhar BTR Assam may consider the prayer petition requesting security, requesting for personnel security officer,
Personal security as well as, my lord, security of
The
PSO,
PSO and property also.
PSO. কি করলো? The prayer petition of the petitioner dated 6/2/2024 requesting PSO. Prayer petition dated 6/2/2024.
in accordance with the guidelines.
I have not come for restriction of my affair. I have come specifically.
What is the meaning of acting upon the affair? Say that specific, bring specific allegations. We'll
My
look
lord,
into.
if necessary, we'll file supplement.
156(3) is there, my lord. He can approach
I have
the
not come that.
jurisdictional
I have not
magistrate.
come for that. Published.
On the last occasion,
None appears for the petitioner on call. Accordingly, this writ petition stands dismissed for non-prosecution.
Last occasion, the Sonabul court directed.
Yes, Mr. Madam, this is, I think this is the third or fourth repetition. We are having the grievance is that the police are sitting over the orders of magistrates.
Yes, madam.
We are not executing court as such, but we could take notice of this. If this is the way, then therefore we sought for an instruction.
They have not responded. I've written to them, madam.
Let the office Gorsuk police station be he personally present at 2. You have the instruction whether
One chance-
whether the commissioner of police will be here at 2 or you will have the instruction at 2.
Madam, on Monday.
No,
Sunday.
at 2. You have the instruction. Can't they give an instruction?
Yes,
Are they
madam.
so busy?
Yes, madam. Very unfortunate. I've written to them formally.
The officer will want him at 2. What he has done, unless gives you an instruction.
I'll convey.
Is there not issue?
That officer, Gorsuk police station.
My lord, this is, I have written to the
Equivalent.
superintendent.
Okay, you have a instruction from the superintendent.
The commissioner of police.
Not commissioner, superintendent of police.
I-
The person to whom you have written will not burden others.
Party.
Okay. No, you have written to whom?
Commissioner of police.
Okay, you just have an instruction.
I-
Or otherwise you'll ask this officer, that Gorsuk, to be present. Because what commissioner will do, just he can give the
In
instruction.
that case, can it be on Monday?
You have the instruction,
I
let
will,
us
I
see.
will try my. best.
May not be even 2, you may get before that also,
Yes,
not
I will
an
do
issue.
it Once, my lord.
And you also enlighten on what is the remedy of this citizen if magistrate is not acting. And what is the provision under the CRPC or what's 145 when a magistrate exercising power under 145, if his order is not complied with by a police officer, what is the remedy and how can he implement his order? We want to get enlightened on this because we are getting many repetitions.
Yes.
This should not be a subject matter of repetition. Yes,
No, I'm appearing for the respondent bank.
yes, tell us.
That hold was temporary hold.
Hmm.
It has arisen of out of the wife of deceased wife of the petitioner
Hmm.
who had taken a loan from the bank.
Hmm.
Now, while she had submitted this loan application and other
Hmm.
things, his name was there
His name was there as
Yes.
what?
as legal as another
Okay.
thing. So when the account became NPA,
Hmm.
so naturally that account also got
So is he a loanee?
no, he's
Is
not,
he a guarantor?
no, because legal heirs are there.
So therefore,
there was
where is the provision
I
and
understand.
power? You show us, tell us that you can seize an account of a legal here. You show us the provision. We are not saying anything or you
No, we have removed the hold. We have removed the hold.
remove.
Yes.
That is correct, my lord. If
If
he's saying
remove the
No,
whole,
yes,
one more prayer is there, because as you for lordship, because lordship paragraph 8 I have clearly said, this intention was their intention to.
that is, so you are issuing a notice.
That is,
Why we call them to be here?
yes,
So that we can, if necessary, we can pass an interim order in their presence.
yes.
Now, therefore, since they are
Yes.
saying that they have done it, we
Yes,
are
yes.
issuing a
That
notice.
is my prayer, it
Okay.
should be kept pending. Let
Okay,
them
no, we will
show.
issue a notice because the other issues will be
Yes.
whether they can even, because you have made statement regarding this loan account and all.
Yes, that's
It is not that you have not stated.
And I have stated, my lord, that is there.
No, kindly
So
state
you take a state that no, that cannot be. We'll pass a appropriate order at that time, but not as regards his account.
No, I have stated here. Kindly let me read.
Okay.
Now, with reference to the subject above, we hereby inform you that the said savings account number standing in your name and maintained with the Amguri branch had been temporarily put on hold arising out of a term loan maintained with our Khanapara branch and which has been classified as NPA on 28/9/2023 due to non-payment of installments standing in the name of your deceased wife, Archana Borga. Since your name and other details have been referred to and mentioned in KYC documents and loan application in your capacity as the husband and one of the legal heir and representative, your account was put under temporary hold by the system, and the said temporary hold had since been removed
Remove, no
Uh,
problem on
as
it.
as on date.
That one, no problem.
No problem.
And we are not even taking any action against them also.
No action will be
No,
against
no, nothing.
you, no
nothing.
lordship
No,
will
not-
take.
not-
Well,
not at this.
ultimately, thing is that it is a pension. We'll see where.
Yes, we
how-
will not do,
Definitely,
will not do
no.
that.
Okay.
Will not do that. It was
So-
just temporary technical. hold.
Okay. No.
Let him submit then.
No, we are not going to that aspect of the matter right now. You
Yeah.
file an affidavit, short affidavit, then.
Yeah.
The preliminary grievance of the petitioner is that the primary, not preliminary, primary
Yeah.
grievance of the petitioner is that the branch manager of State Bank of India, Amguri branch has abruptly stopped the operation of the saving bank account number 367008293777 standing in the name of the petitioner. Full stop. This court, under its order dated 22/3/2024, asked the petitioner to furnish a copy of the writ petition along with the order passed on 22/3/2024 upon the respondent bank. Accordingly, Mr. Sakabati has appeared on behalf of
Yes, doctor.
as the doctor has appeared for the State Bank of India upon receipt of a copy of this order. Do you need extra copies?
No,
Okay. The Learned Counsel has produced a communication from the communication dated 27/3/2024 issued by the Chief Manager,
Khanapara branch.
State Bank of India, Khanapara branch, addressed to the petitioner, according to which, though a temporary hold on the account,
Technical hold.
due to some
Temporary technical hold.
temporary technical
Hold.
hold was operating as regards the said account. However, same has already been withdrawn. Had since been removed as on 27/3/2024, and the petitioner is free to operate the said saving bank account maintained with the Amguri branch of SBI for day-to-day transactions. In that view of the matter, no interim order need be passed. However, for determination of other issues, let a notice be issued, returnable after 4 weeks. Mr. Datta accepts notice on behalf of all the respondents. As parties are duly represented, no formal notice need be issued. However, extra copies be furnished to Mr. Datta. List of the 4 weeks.
Orders, item 27.
Motion है कि नहीं?
Actually, this matters are squarely covered, my lord, by a recent judgment of this honorable court, my lord.
What is the issue here?
Petitioners, my lord, herein they are commission vendors with the railways.
Mm.
They were engaged by the railways to run the departmental stalls, my lord.
Mm.
And subsequently in 2011 to 2021, my lord, the decision was taken by the railway authorities to terminate their services. Now subsequently that order has been withdrawn and they have been relocated to some other place. Now that relocation order is nowhere under challenge and they are aggrieved by that. In fact, this honorable court was in fact intimated regarding the relocation order, and that aspect of the matter is recorded in the order sheet also, my lord.
Order dated
Order exact 21, my lord.
10/9/21.
And probably, my lord, and my brother was also present, and in fact, the issue, my lord, involved in this writ petition has recently been decided by court number 12, my lord.
But yes, but there are three commission vendors.
See, be fair to the court.
Yes.
If you say that that is not applicable, that judgment is not applicable, we'll proceed. No if buts.
No, but my submission for your lordship's consideration is little different. But there is little.
No,
distinction-
just first response to his argument that this is covered by a determination.
Yes, that has been determined. There is no dispute as regards.
So determination you don't dispute.
Hello.
Now,
Now, my lord, in that case, factual distinction is this, my lord, that in
so therefore you say that that judgment is not, will not cover your facts.
there is slight difference, my lord. I like to point it out before your lordship, my lord.
So difference is such that we should, that will not cover your case.
Yeah.
That is your case. Okay, proceed. Where is the judgment? Give us.
Can hand over.
But at the end of the day, if we find that it is covered squarely,
Yep.
and just a moment, we'll give you a patient here. At the end of 15 minutes, if we find that it covers squarely and Mr. Counsel is arguing on that, just be ready for the cost. Yes.
Just one aspect, if lordship permits.
No, let him out, let him out.
Tender process is under-
Let him proceed with the risk and cost of having a cost of 50,000. Yes, proceed. Yes, what is the issue here?
My lord is having this judgment.
Not issue. No?
My friend is given. my lord.
This, okay. First, let us understand your facts so that
Yes.
we can distinguish
But in
between the
fact, I'll
facts of
not
this.
not take even 15 minutes. I'll take only 5 minutes to my lord indicate what I
Okay.
wanted to indicate before your lordship.
Okay.
My lord, under the railways, my lord,
Hmm.
but there were licensed vendors
Hmm.
and there were commission vendors, my lord.
Hmm.
But, in both the writ petitions, my lord, the father of the petitioners were given the license for as commission vendor in sometime in 1961-63.
You are a commission vendor.
Yes, I'm a commission vendor. My lord, taking 4500, my lord.
Hmm.
Now, my lord, in sometime in 2004, lord, after the death of the lordship would finally see, my lord. Just I'll indicate to your lordship, my lord. So at annexure 1, my lord, at page 20, if your lordship sees.
Now, where is the termination letter? It's,
That has been withdrawn, my lord.
28/7/2021, my lord.
so termination has been withdrawn.
Yes, yes, yes.
Here the challenge was the termination and subsequent notice,
Yes.
tender notice. Now termination is withdrawn. And what happened to the tender?
It has been decided, my lord. So far as two writ petitioners are concerned, we have received bids and the stalls were settled with the bidders, my lord. So far as
Which petitioner?
the judgment which your lordship is holding, my lord, in that case, it was settled with one.
No, I want to know here two challenges. One is his termination as a commission vendor dated 28/7/2021
Page 96.
and NIT dated 2/9/2021. Okay?
My lord.
Now, according to them, termination letter dated 28/7/2021 is withdrawn.
Yeah.
So there is cannot be any challenge to that order.
Right.
Now, what happened to the NIT? Did you participate in the NIT?
No.
You have not participated. Now, what happened to the NIC? Is his location is settled to somebody else?
In one case, it was settled. In the other case,
No,
no.
in this
Yes, yes,
petition,
yes, yes.
4500.
In one, I'll get the confirmation, my lord. Within
That
30
is the confirmation you require.
one case, it was settled. In the other case, bids were not
What?
received.
Where is your location? Tea stall platform number 6 and 7 between pillar 3 to 4.
Yes, my lord.
Now, whether it has been settled?
Now they are not there, my lord. They're no longer there.
You are no longer there.
No longer
I
there.
have filed an IA forcefully.
I am asking,
No.
why should you just answer this
No, no,
question?
no, but I am no longer.
So you are-
nowhere, I am nowhere.
You are no longer,
I'm
so
nowhere.
my question was subsequent to the tender, your location has been settled to somebody else.
The tenders were floated, but it has not been given. Once it was given, then it was removed. But that location is still subsist,
Hmm.
but I have not been allowed to continue. In an illegal
Okay.
manner, I have been thrown out.
Okay, so according to you, that plate pillars between 3 and 4, the tea stall pursuant to your commission vendor is, you are no more in, but what happened? That was withdrawn.
Which one, my lord?
His commission vendor letter, termination letter was withdrawn.
Withdrawn. They were allowed to continue after the bids were received and tender process was finalized. They were given notices to relocate their stall. And this aspect of the matter was brought to the notice of the honorable court also. These are the relocation order, and they have
They
specifically.
are got relocated or what?
Yeah.
Are you got,
We have
They are
been
not
given an
willing.
offer. We
you have not
been
accepted
offered.
that?
No,
They have
that-
not
that is-
accepted.
That is,
You have not
Not
accepted.
accepted.
So you want 3 and 4. That pillars number 3 and 4, the earlier location. And
6
then
and 7.
according to you, so therefore it is vital whether pursuant to tender notice dated 2/9/2011, it was settled with somebody or not. That is vital?
Yes.
Is it
No,
settled?
not at all, my lord.
Not,
Not
was
at
not
all, my
settled.
lord, because this judgment
Hmm.
has upheld the right of the railways to relocate the stall. These are not licensed vendors, my lord. There is a difference between
They are
licensed.
commission vendors.
They're commission vendors. Licensed vendors are those who, after participating in a tender process, are granted to run a particular stall mine for a particular period.
Now, what is the ratio in this judgment?
The ratio is that the railway has the right to
Where is that
relocate.
paragraph?
My lord.
Nobody is ready. These are the vital questions.
Mark the paragraph 1920,
These are the vital questions.
1920.
Tender is same, relocation is same. He is arguing that this is not, this judgment is not applicable to you. So let us have the ratio first, then we'll see his facts. If it is applicable with 50,000. If it is not applicable, we'll go for further hearing.
Paragraph 9,
Yes,
the paragraph 9 indicates what is the contention of the petitioner in the case. Then thereafter, my lord, in paragraph 14,
tell us the ratio where it has been said that this commission vendors termination or relocation is permissible, that is not being interfered.
my lord, 16, 17, 19, and 20. I'll read out. May I read, ma'am?
Okay.
Reverting back to the facts of the case in hand, as have emerged from the agreement dated so and so, the petitioner herein is only a commission agent simpliciter without any kind of interest in the property in question. That is the stall located at platform number 1 between pillar number so and so of the Guwahati railway station. The documents referred herein above and from the case papers, it has clearly emerged that the respondent NF railway authorities had sought to relocate and had relocated the petitioner, who is a commission agent, from the earlier place located at platform number 1 to another location at platform number 2, 3. There is nothing to indicate that the agreement, which has a validity period of 5 years, has been terminated. The source of the power to relocate a commission agent like the petitioner herein is traceable to clause 5 of the agreement. By clause 5 of the agreement, the NF Railway, as the administration, has reserved the right to introduce rotational system of vending, and the administration can change the place of work of the commission vendor, and in case of such relocation, the commission agent has to perform his duty in the manner stipulated by the administration. In the year 2017, the Railway Board, Ministry of Railway, Government of India, with the objective to provide quality food to the passengers of trains and to extend better catering services on the trains, had envisaged the catering policy 2017 in supersession of earlier catering policies. It is pursuant to the catering policy of 2017, the stall located platform number 1 between pillar number so and so of Guwahati railway station has been categorized as a general minor unit. As in the meantime, the
Forget about all this. Where are you reading? Come to paragraph 19, last 4 paragraphs. And paragraph 16, last 3 paragraphs.
Paragraph 16.
Yes, the source of power. Read it.
The source of power to relocate a commission agent like the petitioner herein is traceable to clause 5 of the agreement. By clause 5 of the agreement, NF Railway as the administration has reserved the right to introduce the rotational system of vending, and the administration can change the place of work of the commission vendor, and in case of such a relocation, the commission agent has to perform his duties in the manner stipulated
In the administration. Now come to paragraph 19.
19. As has
The
already
legal, don't read all this. The legal issue as regards.
the court is not interested to go into such dispute.
Forget about
The legal issue,
last legal issue.
The legal issue as regards the right of the petitioner to continue his business as a commission vendor from the stall located at platform number 1 between the pillar number so and so of Guwahati railway station has been found to be in the negative, as the petitioner as commission vendor has no legal right to assert that he as such commission agent can demand to run the business from the particular stall.
Okay, now tell us what is your case. This is the ratio. Forget about other facts. That commission vendors are having, they are commission vendors. They are having no right to run their business from a particular location, and railway is having a right to relocate. Now, what is your case?
I'll kindly come to page 21.
Page
21.
21 of what?
1500.
Yes. According to you, you are not a commission.
I am.
Okay.
Here the clauses which, well, I am continuing on the basis of this letter. That has not been renewed, that has been continued.
Not at all.
What is that clause 5? That relocation.
In these two cases, my lord, after this particular letters, they were supposed to enter into a contract. That contract was never entered into. On this basis, they continued. In the other case, the contract was entered into, my lord. In fact, in the other case,
Where is that contract is to be executed?
my lord,
Where is that?
that's the rule, my lord. And in the other case, this letter which is citing, it has already expired. It was for a particular period only.
Hmm.
In the other case,
No. His case, as we can understand, he says that in that earlier case, there was a clause 5 which determines this right. In his case, there is no such
In
clause.
fact-
This is your case.
in fact, that petitioner was on a much better footing, my lord.
Oh, forget about that. Now tell him that ratio is applicable because you need a clause 5. Where is that clause 5?
Now, these particular aspect, my lord, regarding the right to rotate the place of vending, my lord, it's an inherent right with the railways. Because why I say so?
Inherent right from the right follows from where?
Because, my lord, these are railway stall. He's just a commission agent. Whatever is sold,
No. Railway cannot have everything on their own. If it is a commission agent, this judgment is passed on the basis, a ratio is laid down that commission agent is having no right to continue in the same location for the reason that clause 5 of the contract provides that this is the characters of a commission agent. Now show us where is that clause in this present case.
in this case, my lord, the contract was not entered into, and as such, it is not reflected. But
Now,
the-
if not reflected,
I
then how, which will guide the rights and liabilities of our parties between
No, no.
railway and the commission agent?
I'll show one thing, my lord. In the other case, it's mentioned, my lord. In the other case, if lordship takes up, it's mentioned out there. my lord.
Other case means,
There are two cases, my lord.
no, it's so, let us come to this case first.
4506, my lord.
Suppose you don't have a contract. In respect of this there may be many reasons. But your source of power and to conclude that these commission agents are defined as this only. Okay. And this commission agent statutorily, all by virtue of certain things, you railway have a power to relocate him. You show us that,
That
then
guide-
in the absence of a contract also will go there.
Yes, my lord. There are guidelines, my lord.
Where is that?
My lord, It's not annexed out here, but the other writ petition, it's there, my lord. It's his document. I can show it, my lord. 4506. Page 20.
Page 20.
The predecessor of the petitioner in the case, my lord, the
Where is the
letter-
contract? Show us.
Page 22.
Page 22.
page 20, lord, will take up for a moment, my lord. This person was predecessor in interest of the petitioner, my lord. Subsequently, it was transferred to the petitioner. In clause 2, it has been written, narrated, my lord. You will have to abide by and adhere to the existing rotational system procedure as prevalent at Guwahati and to the other instructions as may be
Okay.
issued by the rule. And maybe, my lord, they've forgotten to
Incorporated
incorporate it, my lord.
page 20.
Anyway, my lord, 22, on the basis of this letter, my lord, he cannot claim any right because it has expired on 36/2005 itself. There is no subsisting right with the petitioner, at least in this case, my lord.
So this was up to 2004.
2005, 36/2005. Page 22.
Okay.
So his continuation is totally, my lord, illegal,
My friend has made a U-turn, my lord.
without any power. I'm not making any U-turn, my lord. If he says, my lord,
Okay, we get your point. But you show us the source of authority.
I'll
That-
today I'm not having that. my
So
lord.
now pay cost 50,000 by railways.
Otherwise, this is otherwise covered.
No, not covered. Ratio is that in terms of this contract, they will have no policy. In absence of a contract, if you can show that this is the principle and this is the source of power of railways on the basis of which these persons are not having any right to be in the same place, then that judgment will cover.
At least,
So therefore, how much cost by railways
at least in
for wasting judicial time?
at least in the other case, that rotational system policy is reflected out there, my lord. At least in
We'll take
4506.
both the methods together. Yes, when?
Anything,
With cost of rupees?
my lord, these are
Whenever you say that this is covered, don't expect at least this court to go by that covers means covered. We'll see find out the ratio.
the
What is binding upon us is the ratio.
ratio. Understand?
Nothing more,
What-
nothing less. On the prayer of the learned standing council for the railways, list this matter after Bihu vacation.
I'll bring the, I'll file an
You have to
appeal.
show a source of power. That's why we are here, 226 court.
In fact, my lord, this got separated.
Let my
That
friend file an affidavit. I'll respond in between, my lord, since time is there. Because they will be introducing.
Do whatever you like.
Yep.
I do not think a policy should be brought in by open affidavit. He can give you a copy of the policy, like showing a judgment, isn't it?
Because, my lord,
Yes,
will
yes,
just
next case.
give me half a minute, my lord. My lord, he says my contract has terminated 2005. They terminate me in 2021 and still they say that has been withdrawn.
We'll see it.
If we say,
No, but basic fundamental argument was that this is covered. We'll come to that later on. Prima facie, because why should you waste time? If it is covered, we'll go by the judgment. For that, we'll know the minimum facts for taking a decision that it is covered or not. And we are arguing for that 15 minutes on that point.
Once, my lord,
It's
he
a
is
good
finished.
case
my lord,
for fit case for cost, but because today is today is Friday. That's the-
Thursday.
Yes.
I'll take
Okay, next case, next case.
I'll take another 5 minutes next day, my lord, to say that where the judgment ended, it should have extended, my lord.
Anything?
My lord, I have gone through everything, my lord.
Hmm.
I have received instruction from police, there was a FIR file
Hmm.
wherein my lords directed
Hmm.
to take instruction. Before, well, facts are so clumsy, it is very dangerous to venture into this case. Both sides are, nobody is innocent.
That's why we have.
Nobody is innocent, madam. And basically, it's a private dispute.
Absolutely private
Series
dispute.
of private dispute. In the guise of 226, madam, they're trying to invoke public law remedy, madam, which is not permissible.
So therefore, we are, one thing is, I have gone through, one thing is fine that if any grievance so far relating to this issue, that misbehavior by their
Yes,
sons, daughters,
yes,
there is a competent tribunal, there is a power
Exactly.
of exercising, that there is a protection officer.
exactly.
Let them file an application, go there. We are
Exactly.
not venturing to
Because-
any comment we made here may affect right of them before the civil courts in either parties. Where is
Son
the
files, my lord, suit for ejectment against the mother
Hmm.
to his wife.
Hmm.
Maybe to hide, my lord, because his father is and her wife, the husband was same. Then it was withdrawn.
Yes. Madam, everything is functioning, go there,
Everything is functioning?
go there. You file a petition before the tribunal, which tribunal will be here?
For that, my lord, I would like to take your lordship. Only 2 sections of that act, my lord, that will be very relevant, my lord.
Keep the copy of the act and keep a copy of this act for us also.
Extra এখন দিতে হবে আর এখন দিতে এখন দিয়ে এখন আপনি এখন কপি করে রাখবেন my lord,
Okay.
section 7(1), my lord, of the act,
Of the act, section,
7(1), it will be at page 4, my lord.
yes.
The state government shall, within a period of 6 months from the date of the commencement of this act, by notification in the official gazette, constitute for each subdivision 1 or more tribunals as may be specified in the notification for the purpose of adjudicating and deciding upon the order of maintenance under section 5. That tribunal, while the other bunch of documents, second page is the constitution. Madam.
That we have seen. in
2nd
the-
of August 2008. There are all orders are, these all notifications are same date, madam. Second page, madam, under section 7(1).
That is a protection officer.
Second page, madam, will see.
Second page of this second batch.
There are 3 notifications. Second notification.
Also, this
In exercise of powers conferred under 7(1), the Maintenance and Welfare of so and so Act, the Governor of Assam is pleased to constitute in each subdivision civil maintenance tribunal for the purpose of adjudicating and deciding upon the order of maintenance under section 5 of the Act with subdivisional civil officer of the respective subdivision of the state. So it is the tribunal. Then if I may take your lordship to section 15(1), my lord. Section 15(1) is that, my lord, the state government may by notification in the official gazette constitute an appellate tribunal for each district to hear the appeals against the order of the tribunal. That notification, my lord, files at the last page of that last page. In exercise of powers conferred under section 15(1) of the Maintenance and Welfare of Parents so and so, this appellate tribunal is the deputy commissioner. So SDO civil is the tribunal, appellate tribunal is the district commissioner. And then, my lord, section 18(1), my lord. Section 18(1) says the state government shall designate the district social welfare officer or an officer not below the rank of district social welfare officer by whatever name called as maintenance officer. This maintenance officer has a crucial role, my lord, though it's not.
protection order and all.
Yes, there is one.
Service provider.
Excellent. There is one more aspect of this maintenance officer, my lord. Section 6, subsection 6, my lord.
Yes.
Section 6, subsection 6 says the tribunal, before hearing an application under section 5, may refer the same to a conciliation officer, and such conciliation officer shall submit his findings within 1 month, and if amicable settlement has been arrived at, the tribunal shall pass an order to that effect.
Yes.
Explanation: for the purpose of subsection, this subsection, conciliation officer means any person or representative of an organization referred to in explanation to subsection 1 of section 5, or the maintenance officers designated by the state government under subsection 1 of section 18. The section 18(1) maintenance officer can
That's-
also act as a conciliation officer.
That is already their social welfare.
The tribunal may refer.
Ah.
That's the position of law, and these are the notification. So
Yes,
it is
madam.
a fit case if the petitioner approaches the.
There is a report from the protection officer itself, who happens to be also the maintenance officer, now we have come to know. That report, I don't know if it has been submitted to my lordship's file. It has been filed. I have been,
Now, what is the prayer here?
if you peruse that, you.
No, what is the prayer here? Tell us.
That there is substantially other problems as well. It's not just maintenance. It's about protecting the lady from the abuse.
So that is under the protection officer can pass an protection
Yes.
order.
Now, he, I believe, is waiting for lordship's order.
Who is waiting?
Lordship will not exercise a power to
No,
adjudicate private disputes, my lord.
Not private.
These are
dispute.
private disputes. I can show
This
from
is-
records, my lord, the social welfare officer writes that yes, there are issues. And I have a report received from the
I-
police yesterday. It is, my lord, it goes against the petitioner again, my lord. Social welfare report is in favor of the petitioner. Police report is against the petitioner, my lord.
That is
So let
the
us
norm
not
of the
endeavor
day.
to all this.
Exactly. So better course of action
I-
will be to approach that forum, my lord.
No, I have a humble submission, my lord.
What
It's
is
so-
this? Give the main writ petition.
It so happens that there were other petitions, writ petitions filed for water. There were so many other cases going on against her, or she has filed a few cases. So it all has to come into one table. And we have to ensure that they live amicably, that family lives amicably. That's all.
There is
I
section
am-
7 petition, my lord.
I am saying that maybe this is functional, but the protection officer didn't inform us about his authority within this act as well.
So my lord will direct the protection officer and the tribunal to take a suo motu cognizance because there is a provision of taking suo motu cognizance.
Perfect. That's all I'm praying. for.
Yes, that will be better, my lord.
Heard.
So
Learned counsel for the petition.
section 4, subsection 5, my lord, power of taking suo motu cognizance by tribunal.
Learned counsel for the petitioner. Also heard as Chakraborty for respondent number 5 and 6. And Social Security Department. Full stop. Mr. P.N. Goswami, learned additional advocate general, has appeared on the request made by this court and obtained such and vital instructions. Full stop. The present writ petition is filed to issue a writ in the nature of mandamus against the respondent number 1, 2, and 3. That is, likhi labo, huh? Likhi labo, huh? 1, 2, and 3. 1, 2, 3, and 4. To protect the petitioner with person and property by visiting the house of the petitioner, who, according to the petitioner, is a senior citizen, with a further direction to check the mental health of the respondent number 5, who is according to the petitioner an addict of alcohol, and the respondent number 6, who according to the petitioner is the merciless daughter-in-law. Full stop. Thus, the basic grievance of the petitioner is protection from her son and daughter-in-law with allegation of misbehavior by the said son and daughter-in-law. Let us not comment on the cases. It may affect either of the party. Full stop. Mr. Goswami, learned additional advocate general, submits that in terms of section 7, within bracket 1 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. And in terms of section 15 within bracket 1 of the said act, the Governor of Assam was pleased to issue two separate notifications dated 22nd of August 2008 constituting Maintenance Tribunal and Maintenance Tribunal as well as Maintenance Appellate Tribunal. Maintenance Appellate Tribunal. It is also submitted that the social welfare officer has been designated as the protection
Maintenance officer.
maintenance officer.
The district social welfare.
This district social welfare officer is also notified as maintenance officer. Full stop. It is seen that the Act 2007 has enacted to provide effective provision for maintenance and welfare of parents and senior citizens guaranteed and recognized under the Constitution and for matters connected therewith or incidental thereto. Incidental thereto. A perusal of the Act shows that it is a complete code in itself with a power to the state to frame rules. The Act also provides protection, passing of protection and maintenance order. That being the position and in view of such specialized tribunal constituted, the petitioner is relegated to the said jurisdictional tribunal, full stop. Accordingly, the present writ petition stands disposed of, permitting the petitioner to file appropriate application before the tribunal, and in the event such application is filed, same may be taken, same may be decided as expeditiously as possible, and also and the tribunal shall also consider, tribunal / social maintenance officer shall also consider the prayer of the petitioner for any maintenance or
Enter-
protection,
Entered under Act of
protection order permissible under
2007 Act.
permissible under 2007 Act.
Suo motu cognizance.
If you files an application, there is no.
That is no, you file an suo motu is something different. Suo motu, they will not know what is your claim. You file a detailed application. Accordingly, with the aforesaid observation, this writ petition stands disposed of.
Only one thing, I suppose, madam, the notification has been recorded as 22nd August. It is
No, 2nd of August.
2nd of August.
2nd of August. Disposed of. In view of other parts in the connected writ petition, I stands disposed of. Keep this book for the chamber. Yes, next case.
Highly obliged. Highly obliged.
Lordship, both the councils are on lake in code number 8.
What the councils are on lake.
It may be taken after some time.
We'll conclude today. No way out. Because this was the understanding. We cannot keep a bench 3 method like this. We are sitting in a bench 4 and 5 method.
Well, they have filed the written argument and your lordship wanted me to go through it and make whatever submissions I want to make on the basis of the.
When?
Today, my lord.
Today. You make a, otherwise we'll release it from part. Because we have given enough time, written arguments are being filed, even or lawyer also are good, so that we can complete it and.
Only 10 minutes maximum.
Okay. Go through it and we'll do after something.
Kindly pass over for the time being.
Why?
Mr. Singh is on his legs in another court. He's the senior counsel.
You show us that when it is, your whole argument was that when it is an exercisable, it is exercisable.
Yes.
It is to be. This is your argument.
I have given a book list, just one SCC.
Let us do, it is after vacation, after Bihu vacation.
For the timing,
No, not timing, because,
ninth,
see, let me be frank, I'm not here for, before Bihu from the next week. Okay, so let this not be an,
Mr. Singh is also in other items. Lordship will pass whatever order in his presence.
Okay.
Only for the time.
okay.
Yeah.
Because in this matter, we have heard Singh and we have recorded everything, whatever his argument. Only we have given him time to on that position, that whatever bonded or not bonded, who will pay that? Moment it comes from the, it is manufacturing, who will pay? That is the issue. Mr. Singh will hear all these part-heard matters and all after Bihu. Otherwise, you are having a stay order.
Is of no consequence, my lord, because I have
Already.
already deposited parcel amount.
Okay, anyway, we'll decide on the next day.
May I get it fixed, my lord?
Fix, we'll give a fixed date immediately after reopening around 28 as part-heard. This part-heard matter will remain as part-heard 28. Because before we, to be frank, before we leave, the all pending works is to be cleared. So, Mr. Bhattakur works are not here only. You will have to carry it here also.
Is it 20, my lord, or 28?
23.
23rd.
Third.
Item 10.
Talukdar, same, 28. Huh? 20. 28th of April.
Saturday.
Saturday, then
Special court opening.
we can do that if you are agreeable. You can ask the permission. 25th? 25th.
So obliged.
I'm also ready with so many judgments.
Don't bring so many judgments.
Somebody.
We want to give you relief. Now we are trying it. There are some difficult propositions that we are asking Mr. Pujari to help us.
His husband.
Which judgment? Tell us.
Read appeal. That's appeal and now contradictory view in the.
Which judgment?
And some of the apex court, the judgment.
The extractor was regularized.
Well, Lordship may kindly fix on Monday.
Which Monday?
Mm,
You will have to come somewhere else to argue this
No,
case.
no,
You want to argue here or you want to come to some other place to argue? Huh? Here?
Yeah.
Then it is on 23rd or 20.
I'm obliged.
My lordship, only the cutoff date will be remaining.
Remain.
And they, in last day, they have stated that there is no express provision like that.
We'll see on the next day. No longest matter.
I am your lordship as an amicus.
Oh, that matter.
I have your lordship filed the note, your lordship, along with.
We had some different plans in mind. That's why we have fixed all this matter on this date. So that you can utilize this next 4 days. But that will not happen this time.
Or your lordship may fix it after, immediately after vacation.
Immediately after vacation, around 19th. Okay,
No, not on 19, my lord, after 19.
give a date as per convenience.
Then the next. 24th.
24th. Parted, all these parted matters are date with parted. This was item number. This is a parted matter, huh? Keep it as a parted. 11 is a parted.
Please, your lordship. Lordship, we are being led by Dr. Ashok Saraf in this matter, lordship.
The matter
Lordship,
stands adjourned on the prayer of.
No, your lordship, actually, this matter will take some time for Dr. Saraf to argue.
Hmm.
So if your lordship may pass it over for timing, lordship.
No timing.
Your Honor, my only submission in this is that there's a stay operating against the commission since 2018, so it's almost 6 years now. And the stay is on the investigation that the DG is conducting into the cartelization of the cement manufacturers, who are the petitioners here. So now the stay being, the stay is affecting us.
So we are
prejudicially.
fixing next week.
Lordship,
Please, Your Honor.
after Bihu break, lordship.
No, he says, then let us not extend the stay.
I'm comfortable with that, Your Honor.
He's comfortable with that.
Lordship, if it can be on 30th of April, lordship.
No, he's saying that he has no objection. You can take it in the month of May also, but will not extend the interim order. He's comfortable. What about your comfort?
Lordship may then,
Next week,
next week, lordship,
give a date.
And
We want everybody should be comfortable.
4th of April is, I'm comfortable, Your Honor.
4th of April,
Deeply.
both are comfortable.
lordship, interim may continue.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on 4th of April. Interim order pass earlier shall continue till then.
Obliged, Your Honor.
Item 14. May I please, your lordship?
Yes.
This case, your lordship, the impugn order, your lordship.
Yes, what is the issue?
Your issue is, your lordship, compensation was paid, your lordship. After payment of compensation, your lordship, they say passed an order saying that you need to refund a certain amount of money, around 22 lakh, which was wrongly calculated. That's their stand, your lordship, by applying wrong multiplier, your lordship. Now, on the basis of that, your lordship, that order, they have asked me to repay, your lordship. When I did not pay, your lordship, they refund, your lordship. Then when I did not refund, your lordship, they issued a letter to the State Bank of India to stop the entire amount of 89 lakhs from your lordship withdrawing, your lordship. The amount, disputed amount is 22 lakhs, your lordship. And when this order was passed, your lordship, asking the State Bank of India to stop, your lordship, the entire money, your lordship, around 39 lakh was in my bank account, your lordship. Now, disputed amount was 22 lakhs, your lordship. So, your lordship, more than that, your lordship, they have keeping, your lordship, on hold, your lordship. I have not been able to use that amount also, your lordship. At that stage, I came before this honorable court, your lordship. And the issue, your lordship, I have raised, your lordship, is this, your lordship. Once an order has been passed, your lordship.
On the award is passed, that cannot be reviewed.
Reviewed, and your lordship, even if you say that there is a
And
wrong
what should be the remedy?
remedy, your lordship, otherwise also, your lordship, they have not issued any notice to me, your lordship, giving me an opportunity, your lordship, to place my facts, your lordship, my side of this case, your lordship.
Now, what is the, what kind of order are you expecting today?
Today, your lordship, at least, your lordship, the remaining amount of the money, your lordship.
Who is for the bank? Who is for the national highways?
My lord, here actually initially NSA is not meant party.
No, we have seen that.
Now thereafter it was made party by our honorable court. Then I appeared and I contacted this road is not contacted by NSA also. This is by NSA DCL. That is the main constructing agency.
Now, whether NSA DCL is the party or not?
No, and now again because that time
Your
NSA.
lordship will kindly see, the NSCI, your lordship, has already, whatever it is, a requisitioning.
No, requisitioning authority is ultimately Ministry of Road and Transport. Isn't it?
No, because money, whatever it is, if I get, I'll get back.
Where is that all these are implementing agencies. They will construct road. The requiring or acquiring agency is the
Union.
ministry, road and transport, isn't it?
No, here, this, lordship.
So
department-
money, suppose extra money is given, that will go back to the Union of India, not to the NHADCL.
No, that has to go by through NSADCL reload, because we demand, we give to a central government, then they have.
Now,
then-
what is the stand of the Union of India?
Union of India, my lord,
Union of India.
See, suppose if his submissions are correct, that the dispute is 22 lakhs. We'll ask the bank to keep 22 lakhs,
yeah, that
not
can,
release and rest be transacted.
Your lordship.
Account can be allowed to be operated, subject to a limit that there should be 22 lakhs rupees kept intact in the account.
Lordship. And in
Yes,
fact,
that-
your lordship, bank has filed an affidavit
Hmm.
saying that, your lordship, that account number until further order and the amount to be blocked was stated to be 89 lakhs. But at the relevant period when the letter was issued, there was an amount of 39 lakhs, 5,272. Disputed amount, your lordship, was 22 lakhs. That is, will
We
be.
will assert in that this is the disputed amount.
No, your lordship, they have mentioned it, your lordship.
No, not State Bank.
No, not by the authorities, your
Who
lordship.
has requested this State Bank to stop this bank to
Additional deputy commissioner.
that is
your-
Kala.
Your lordship may kindly come to
Kala,
page
Kala.
31 of my writ petition.
Yes, I am at page 31 only.
Lordship, with above mentioned subject, cited, it is informed that as per letter number so and so directed by the office of the under did to deposit the additional compensation of rupees 22 lakhs 22,000.
Yes, Mr. Sharma,
Lordship.
what is your state?
Regarding the rest part, Lordship, we have mentioned earlier also that that can be released by keeping that much of amount, and accordingly by order dated, this honorable court has directed us to file an affidavit by the order dated 8/12/2023.
Okay. Have you filed that?
Yes, Lordship. We have
Where is that affidavit?
affidavit is there, starts from page 41, I think, Lordship. It's a running page.
10-1.
Page 41, running page. Then where is the,
Paragraph 3.
I was expecting that at least an affidavit will have 3-4 pages. So I was searching.
No, Lordship, that's because I have pinpointed the
Anyway,
man, Lordship. In
Affidavit
paragraph,
ends at the second page
Lordship,
with everything,
Lordship,
with notary and everything,
Lordship.
stamp vendors. And that includes true to knowledge and belief. And also includes the name and
no,
designation and everything. Anyway,
Paragraph 3, Lordship, why it was deducted. The calculation should be 1.5, but it was.
no, I am seeking, getting some different affidavit, not your affidavit. That is what
The affidavit shown by
Sweat for-
Damodar Burman.
Manoj Kumar Das.
No, Damodar Burman.
Here is one affidavit,
Affidavit filed as per the
Of
Honorable High Court's order
one-
dated 8/12/22.
Mukhal Sahu,
Pral Sahu is by me.
then Manoj Kumar Das. No, your affidavit,
Thereafter. In the second file, it is here, Lordship.
Damodar Burman.
Yes.
There is
Damodar
no
Burman.
pagination of this affidavit. Oh, 55.
Oh,
That's why.
In the second file, Lordship, which I have taken the second file, but
Oh.
it's 41.
Yeah.
In page 40, paragraph 3, Lordship. Paragraph 2 is the direction of this honorable court, and according to paragraph 3, why it was deducted.
Okay, heard. Mr. Bothakur, learned counsel for the petitioner. Mr. Bothakur, you do whatever necessary, will not pass anything. Bothakur, learned counsel for a petitioner, Sharma for Kala, deputy commissioner, which?
Your lordship, 2.
Give a slip, Mr. Bothakur,
Lordship,
who is appearing for.
Lordship.
Let us not waste time on that.
234.
Agreed by a letter dated 2/3/2019 issued by the additional deputy commissioner within bracket revenue Golaghat, directing the respondent number 5, that is State Bank of India, Assam Gramin Vikas Bank branch,
Your Lordship, bear down.
Golaghat branch, not to allow the petitioner to withdraw any amount from his account. The present petition is filed. An affidavit has been filed by the
On behalf of respondent number 2 and 3.
affidavit has been filed on behalf of respondent number 2 and 3.
3.
That is the
Deputy
respondent-
Commissioner and Additional Deputy.
Deputy Commissioner and Additional Deputy Commissioner of Golaghat district, wherein
It's shown on the one.
it is stated that
234.
while granting land acquisition compensation, there were certain mistake of use of multiplier. Accordingly, an amount of rupees 22,22,638 was wrongly transferred into the bank account of the petitioner, which is maintained, bank account of the petitioner, which is maintained in the respondent number 5 bank. Respondent number 5 bank. Mr. Bothakur, learned counsel for the petitioner, on the basis of such affidavit, submits that even if the issue whether after passing of the award, the authority is having, whether the authority is having any power to seek refund of the awarded amount paid, the petitioner is entitled to operate his bank account, and he is entitled to transact money beyond the disputed amount of 22,638 kept in his bank account. Accordingly, he submits that the petitioner may be allowed to operate the bank account for present balancing the right claim by the respondents. Full stop. Mr. Sharma, learned counsel for the representing the deputy commissioner, submits that the concern of the deputy commissioner is that the money wrongly transferred into the bank account of the petitioner shall be kept intact in the bank account till determination of this writ petition. First up, considering the arguments advanced by the learned counsel for the parties, this court is also of the view that the petitioner be allowed to operate the bank account by keeping a minimum balance of 22,22,638 in as much as at present, according to the bank, amounts kept are more than 22,638. Full stop. Accordingly, it is directed that the respondent number 5 bank shall allow the petitioner to operate his bank account being give the bank account number being so kept in so subject to the condition that the bank will not allow the petitioner to bank shall kept a minimum balance in the account of the petitioner amounting to rupees 22,638.
Your Lordship, Gramin Vikas Bank, there now.
Just give a note, because if there is a mistake, this bank now account number and bank there again. The parties may file their pleadings in the writ petition accordingly. Also, writ petition be taken up in the admission column after 3 weeks.
Obliged.
Subsequent peruse the last order, certain instruction was done.
What happened?
Lordship, I have received the instruction, Lordship, but hearing was taken, my lord, and they came to conclusion that if the canal is kept straight, my lord, then there is less possibility of flood. But another thing surfaced, my lord, they are occupying forest land,
Who is occupying forest land?
those persons, my lord.
No,
It
no.
falls under Raikasini Reserve Forest. So,
Valpara.
my lord,
Valpara.
Valpara.
No, Lordship, I don't have, it is not fact, it is not a fact, Lordship.
It is pursuant to this court's order dated 7/2/2024. It is submitted by Mr. B.J. Talukdar, learned senior counsel, that appearing on behalf of the respondent district administration, that he has received instruction, and as per the said instruction, the drain what you have
So
said,
that is the suggestion of the officials. my lord.
hearing, he have instruction that hearing has already been concluded in terms of this court's earlier, in terms of this court's order dated 18/8/2020, passed in WPC 3133 of 2020. And a report has already been pushed up. A report has also been submitted by the Balijana Revenue Circle, which suggests that petitioners are settled in the Raikkohani PRF, and there may be difficulty in reconstructing the drain as proposed. Full stop. Be that as it may, let such instruction be filed through by way of an affidavit, so that the petitioners can also respond to such affidavit. Respond.
Lordship, I kindly fix a date because it's a old pending of 2020. Lordship.
Okay, list this matter. When Mr. Talukdar, can you?
Election.
That is the difficulty, May. That's why we are saying after 4 weeks. You make a mention.
Lordship. Because the rainy days are coming, Lordship, all the area.
But problem is that this festival of democracy also, we cannot say stop them. And of course, the circle officers will be busy with this festival.
Lordship.
And this is most important festival.
And probably the affidavit will have to be shown by the ADC, Lordship. Okay.
Yes, ADC will be somewhere, election officer, he will be somewhere, something. We can pass an order, but nothing will happen, we know that.
Lordship.
Yes, next. Yes, Mr. Singh. Anything details and elaborate?
This can be disposed of, my lord. My firm was temporarily barred from having its name in the GEM portal.
Oh,
At the-
that case.
At the instance of army authorities, my lord.
How you understand?
It was for only for 3 months, my lord.
That
But
is over.
thereafter interim protection was granted. Despite interim protection, they debarred me. So ultimately I have to file an IA. After filing the IA, they withdrew their debarment letter. But thereafter they started asking the different contractors not to help me or engage my trucks in their contract. Because what happens, my lord, if I am having number of trucks and number of vehicles, I can give it to others also on lease. So all those contractors.
But is there any order? There is no order. That will be verbal.
No, there was written order and we could place the written affidavit, which they were asking from different contractors not to engage. Once that was placed, they again withdrew that order. So now only thing that survives, my lord.
Already withdrawn, my lord.
But how are you doing all this? You are Union of India, mighty Union of India.
My lord,
Can you do that? We
affidavit
will not
is-
say it's Union of India is doing it. That is been done by the officers.
my lord,
Is there any policy decision? Can you show the record that we have decided to not to take, I will ask the other contractors not to take the trucks from
my
here.
lord, otherwise, my lord, there are forgery, there are police case, charge sheet submitted.
That are
all there, my
fine.
lord.
No problem on that.
My
You
lord.
take action against them as per
My lord.
law. We are not
My lord.
interfering with that.
No,
If you want to blacklist them, blacklist them,
first-
but as per law.
At the first instance, my lord, it was not, my lord, they have not properly communicated their main branch, my lord. Because of that first order, subsequently, yes, regarding that, there one affidavit was asked for from the other party. Subsequently, that was also withdrawn, my lord. At present stage, nothing is there. They have
But
participated.
where
in-
is the assurance that you will not do the same things?
Assurance, my lord, now, my lord, they are participating now.
My lord, I have one humble prayer. Since everything originated from the lodging of the FIR, because that FIR gave them the ground to approach the JAM and then to ask for my debarment. Since the FIR has been lodged, the investigation has been carried out. Now they have said in their affidavit, my lord, that charge sheet has also been filed, though we have not received the summon, my lord. Till the outcome is finally decided by the trial court, let not them take any fresh step, my lord. Because
No, that will be a blanket. We do not know, we do. You will have to come once again.
on this ground, my lord, on this ground.
No,
If they
no,
have-
this will be difficult. This will be an absolute blanket order. That cause of action has not arisen. Only that will be only on apprehension. We can understand.
Whenever
We
situation.
can
arises,
understand if this kind of things comes to this court,
they can come.
then
again, my
we'll
lord.
take a view, but
It is
this
an
will.
admitted position, my lord, that it
No, no,
was the
that was an
FIR.
admission
It was-
position, they have done it, this is an admitted position, they have withdrew it. Now, this is also an admitted and settled proposition of law that we cannot pass an order on apprehension. So we'll close this.
That is my only submission.
That
my lord.
cannot be.
No, my lord, in a different way. What they have done because of the FIR. My only prayer, limited prayer is that till this FIR is finally decided this way or that way, because ultimately if the charge sheet has been filed as they are claiming, my lord, whatever is the decision, till then, at least on the strength of the FIR, they will not take any step. On the strength
That
of the
of course they cannot.
My lord, yes.
That is my
What is
limited
what
prayer.
is your prayer in this writ petition?
It was against the debarment that was done by the
5/2/2023. 2023.
Kindly come to page 18, my lord, my writ petition. But these are the orders passed by the GEM portal against the
So
incident
that has been withdrawn.
that has been withdrawn. And kindly
You-
come to
you-
page 19, my lord, page 19. Till the final conclusion in the investigation in Tezpur PS or till final adjudication in the trial, if any. At least till that, that is my prayer.
Then we'll need a determination that this you cannot be done on the basis of this pending affair.
My lord,
Then we'll need a determination that they cannot do. Then we'll make a determination. If since you have a prayer, we'll have to address it.
one thing is that, my lord, yes, my lord,
No, see, he is ascertaining a right that on the basis of this pendency of affair, you cannot debar me from participating in tender. This is his case. If you can satisfy that no, on the basis of this affair, we can do future
my lord,
that is not a proper, yes, one thing is that out of this I am saying. Now another, for the next
Your
year.
anxiety shows that if you want to do that again,
Just,
why don't you say that, no, this FIR is, they have filed it, search sheet is filed, we have no business, we will not do it. This is one way. Or you can say that we can still do it because he is a search sheeted person. We do not want to give contract to this search sheeted person. Then we'll determine whether this is permissible or not.
One thing I am placing for the next year, there are tenders, and there is a clause whether any case is pending or not, you file an affidavit. They have filed an affidavit, not in this record, they have filed an affidavit that I have no case pending. Whether criminal case, succeeded, and these two cases are pending. They have filed this affidavit, so technically rejected for the next financial year.
Very good.
We have filed the KBR also.
Very good.
That
is the way of doing things. That is the way of doing things. You have done it. Nobody will interfere. This is a contender condition. You have not disclosed. Technically not fit. That is fine. But do you propose to say that irrespective of any clause, we have a right to debar a person? If you don't say, we'll record it.
That is not there,
If not there, so that is the issue. If he is insisting that this order should be passed, we'll pass it after hearing it, not today. These are the basic fundamental issues. If you can answer that, no, we can do it, we'll address it. We'll say, okay, there is a power, a search-sheet person cannot be awarded a contract on the basis of this principle, and this principle is not under challenge. That we can say, or we can say there is no such discernible principle, so therefore you cannot do. So we'll pass an order that only for this reason you cannot do.
They also know the law. Innocence, presumption of innocence is there.
The order which is under challenge in this case is the order which I passed, my lord. On the basis of complaint from Ministry of Defence, my lord, that he has admittedly done some forgery. Manufacture the documents, seal and everything forgery is done. On that basis, we debarred it from participating. That is under challenge. Now, before doing that, we issued show-call notice. They get 10 days time, they did not reply. So it automatically.
So we are there.
So system automatically.
But you have withdrew that.
No, I have not.
For what good reason you have withdrawn that?
No, not withdrawn, my lord. Not withdrawn because of the interim
So
order.
therefore, we'll decide the merit that you have rightly done. We'll dismiss the writ petition.
Yes, ma'am.
That's all.
Only, whatever, here the challenge was that why they were not allowed to participate. That cause of action is gone. Because by virtue of the interim order.
No, by virtue of his statement, which we'll examine. If it is correct that you are time and again doing this kind of things, we'll decide this matter, whether you can do that.
No, those
List
are
this matter after vacation, on the prayer of the Learned Council for the party. Yes.
May it be fixed on 30th of April.
30th of April.
Of like.
Item 23.
Yes.
Lordship, as per the last order, the state is supposed to file an affidavit, Lordship, apprising the court as to why they have requisitioned for an approach road.
Yes.
Yes, Lordship, we have received the instruction, Lordship.
Yes.
Because of the status quo order passed by this honorable court, we are unable to proceed under section 6(1) of the.
Okay, let them proceed.
For acquisition, Lordship.
For acquisition. We'll close it.
They may pass an order that they're acquisitioning the matter.
So they will keep it on record, that instruction that for the status quo order they are not doing. And we'll provide that they can, they will proceed in terms of that, in view of their decision, we'll close it. If they are not doing, come back.
The third paragraph, Lordship.
Yes.
After the 30 days of mandatory period, under section 3(1) of accepting claims and objections for the project, the undersigned was supposed to go for acquisition of the concerned land under section 6(1) of the Assam Land Requisition and Acquisition Act 1964. But in the meantime, the office of the undersigned received a court order where it is instructed to maintain status quo on the plot of land of the petitioner. Hence, abiding the court's order, the undersigned has not proceeded for acquisition under section 60.
Lordship, this status quo is with regard to the requisition proceeding, Lordship. There is no bar as to the acquisition proceeding.
How that 64 Act comes in? This is for requisition only.
They're providing this 3-1, 3-1 Lordship.
3-1 is a requisition.
Yes.
We sought, why are you proposing to have a requisition instead of an acquisition? Because purpose of requisition is always for temporary. Suppose there are some refugees. You want to settle the refugees, you want 100 bighas of land. You can require it till they are rehabilitated somewhere.
No,
There are some, you want to,
the road, approach road to a temple, Lord.
then it will be a permanent nature. Will it be a temporary? Or you want to, you propose that we'll close this road?
Yes, Lordship.
Yeah.
100%. It's not temporary, Lordship. This is a letter by the Executive Engineer, PWD Deputy Commissioner, Lordship. This is a part of that letter. I have the honor to inform you that after the demarcation of government land for the construction of proposed Jagannath Temple approach road to Pathargarh, it is observed that the proper carriage where it is available not of the government land for the construction of the proposed road, the required.
So no, that government, that requiring agency requested, PWD requested the
Yes.
Deputy Commissioner to get that, this is the land, we want some private land, so acquire this.
Next phase, Lordship.
This is a
LA case, Lordship, this
LA case is something different, but why under subsection 3 of subsection 1 of section 3?
Yes, Lordship, it doesn't tell you, Lordship. Let me get the instructions again, Lordship. Most probably they have wrongly given the instructions.
Here instruction is that we want to.
Lordship, I got it, Lordship.
We are again saying we want to have a requisition. We want to requisition it, and because of the status quo, we have not been able. Our anxiety is that you want to have a. Her anxiety is that why requisition? Acquired my land. So court passes in status quo. Your instruction again says because status quo we are not prepared. What is this? And in the meantime, for this status quo, the cost will be escalated.
Lordship, it is better, Lordship, we will file an IA for vacating this status quo order by annexing all the documents.
And then we'll do the necessary order for imposition of cost upon these people. This is your money, our money.
Lordship. That's true, Lordship.
Is that it?
I appreciate, Lordship. Yes. Lordship. Yes, to get here now.
23.
Because whole purpose of subsection or of section 3 of the 64 Act is different. That is the ground why status quo order is passed. Mr. Sharma, learned counsel submits that he may be granted 10 days more time to obtain instruction in terms of this court's order dated 6/3/2024. Prayer is allowed. List this matter on after view. Okay, no. Okay.
May I get that copies?
Okay, give it. Yes, anybody wants adjournment, let us know that. Item number 24.
No, Lordship, that
All adjournments which are required and should not wait till 2. Tell us. Item number
29 to 34, the petitioners have filed some additional affidavit in each of the cases.
Okay.
1 week, Lordship.
Okay.
That is not the important thing.
Lordship,
Not
1
to be
week.
directed.
Let us go through it.
List this matter on
Next Thursday, Lordship.
not next Thursday, it is after view. Adjournments
Lordship, and keep it for her, Lordship.
After view. Give a date. 23rd of April. Okay. on the prayer of Mr. B. Choudhury. Today, madam, it's not possible otherwise. Okay, then
Should we kindly keep it parted that?
that will be parted because you have heard it only that affidavit we ask you specifically state that
That
earlier affidavit that you have filed, let him go through it. Parted, huh?
That's it.
And then Mr. Nayak, 24. When Mr. Go, when? Any date or after Bihu?
After the.
After Bihu.
4 weeks, Lordship, otherwise also he is enjoying the.
Okay, after 4 weeks, interim order pass earlier shall come. So that's all. How many methods are there? 2. Can come back.
What's up? God bless you.
But I've received instructions. Although this particular, well, when the threat of enjoying the courtroom is looming large, they respond. This was a case in retaliation. He was already charge sheeted in another case, 447 to 427, way back in 2019. Then again, charge sheeted in another case. These facts have been hidden from this honorable court.
It's come. Come, Metro. Because of the.
Yes. Vedas Police District.
Yes.
Yes, Milan.
Recourse is closed, your lordships, in view of 145, your lordships. The magistrate have lordships.
Yes.
That information to take instruction, your lordship, so that. For last 2 years, the matter has been pending, your lordships. No action has been initiated by the respondent also.
Be that as it may, my lord, it was incumbent on him to declare what he has done before.
There's different issues.
No, no, that is fraud upon this honorable court. Yes, my lord.
Lordship-
Exemplary costs, my
No, no,
lord.
lordships.
Absolutely, nothing has been declared in this writ petition, my
No,
lord.
lordship.
Kindly see the
No, no.
conduct of the petitioner. He must come with clean hands, my lord.
Lordships, now the question is the person who has filed an application before the executive magistrate. Thrice, your lordships. No, the magistrate may not look into the waiting for a police report. He may pass an order appropriately or order for the since the application has been kept pending for last 2 years. The writ petitioner has time and again visiting the office to at least to resolve that issues for peace and tranquility of the matter. So he has helped to before this honorable court to at least to dispose of the matter, dispose of his applications, either this way or that way. Either this way or that way, he may, if the petition.
Niraj Day, my lord. Charge sheeted in 2 cases.
No, that is different issues. Charge
No,
sheeted-
no, that has
No,
not
no,
been
no.
placed, my lord. That goes to the root of the matter, my lord.
No, no.
KD Sharma's case.
No, that is different issue.
No,
He charge
that
sheeted,
must be
that
placed. That was land grabbing, my lord.
No, I have stated in my petition also. My application, I have already cleared all these things. The High Court's order is everything, Your Honor. From RT application to injunction orders. Everything, Your Honor. That page 53 is reviews, everything. Stay orders, High Court stay orders, injunction orders, judicial letter to the authority concerned.
Yes, my lord.
Now we are sending it by way of February.
Executing 28.
Lordship has to see first of when the cause of action arises. I don't know whether it is the before that
Yes.
notification or after that notification. That I have to look into my life.
22, my lord.
We are-
No, my lord, he says that. No, my lord, he
Yes.
says that,
Please before.
yes, yes, my lord, that is there. His application is 22.
So basically. The magistrate cannot resume the jurisdiction once. He cannot resume the jurisdiction. So the he can approach the police now. Still, he can approach the policeman with a fresh application.
Lordships, Lordships. Very good, very good. Lordship. Lordships. I will, I'm taking it out.
I'm sorry, my lord, on the first call, I was not there.
Finish this matter, other matters. Only 4 matters are there. It will take 4 minutes.
Item 25.
EVCS.
Lordship, I have received instruction. I pray for 2 weeks' time to file affidavit.
Okay. Mr. B. Chaudhuri, learned counsel for the petitioner, submits that he has received instruction and will require 2 weeks' time to file affidavit in opposition.
हो गया आ गया